and welcome to Ipsy Dixit, a podcast on legal scholarship. I'm Mabel Romero, Assistant Professor of Law at Northern Illinois University College of Law. My guest is Sarah Sherman-Stokes, Clinical Instructor and Lecturer in Law, and Associate Director of the Immigrants' Rights and Human Trafficking Program at Boston University School of Law. Today we'll be discussing her article, Third Country Deportation, forthcoming in the Indiana Law Review this spring. So welcome back to the show, Sarah, and thanks for joining us.
Thanks so much for having me. I'm really glad to be here.
So I'm really excited to have the chance to discuss this article with you because it describes some phenomena that I wasn't even aware existed. And I'm sure that's true for a lot of our listeners. So I want to start off with getting down to brass tacks, essentially. I think anyone paying attention to the news is really aware that there are large-scale deportations of non-citizens from the United States happening, that they seem to be picking up in pace. Although I imagine that a lot of people who, think about these deportations, they assume that there's some sort of orderly process, including, some sort of, an appearance in court. Maybe there's an attorney that helps out or something like that. But really, you introduce this idea of shadow deportation and third country deportation. What do we mean by shadow deportation here?
Yeah, thanks so much. And I think I really appreciate you giving us a moment to kind of situate this in the larger context of detention and deportation, because this is really part of a growing trend of deportations that happen outside the courtroom. And I should start by saying, there's about 54,000 people detained by Immigration and Customs Enforcement on any given day in the United States. And I say people because some of those are U.S. citizens who are erroneously detained, but for the most part, they are non-citizens. There are estimates that about 6,000 of those in detention, so about 11% of folks in custody, are survivors of torture. Now, that's self-reported, so it's probably underreported. But we're talking about people who are extraordinarily vulnerable. And I'm happy to disabuse people of the notion that there is a fair and orderly process that involves a lawyer. Most folks who are facing deportation do not have a lawyer. You have a right to a lawyer in removal proceedings if you can afford one, which means that most people either rely on pro bono legal services, and of course, there aren't quite enough pro bono lawyers to provide everyone with legal services, or law school clinics like the one that I help run here at Boston University Law School, where we represent folks pro bono who are facing deportation. So you've got a lot of really vulnerable people, survivors of torture and persecution, who are facing deportation largely alone. And what this article sets out to do is kind of explore this brand of what I call shadow deportation. There are many brands of shadow deportation. This is just one. There's also reinstatement of removal, expedited removal. These are processes of deportation that happen outside the courtroom and without the oversight of a judge. And the one that I'm focusing on is third country deportation, which really briefly put is when Immigration and Customs Enforcement, or ICE, seeks to remove a person to a third country that is not the United States and not that person's country of nationality, after a judge has found that that person can't go back to their country of nationality because they will be tortured there.
Okay, so third country deportation, you're talking about sending people to a country that they're not from, have possibly never been to, just a random, completely different location then, it sounds like.
Yeah, it could be. So I can give you, I think, I tell my students all the time that stories are what get us to stop and actually pay attention. It's one thing to talk about the law, but it's much more compelling to actually put a face to the law and its impact. So I'll just mention the story that I start my article with, which is the story of Peter. That's the name I give him. He's given me permission to tell his story with some slightly altered details to more or less protect his identity. But Peter is a young man from Sudan. He was born in Khartoum, Sudan, came to the United States as a refugee after enduring quite a bit of trauma in Sudan and persecution by the government, and came to the U.S. and really struggled as a refugee teenager, struggled with substance dependence and untreated PTSD, panic attacks, and trauma, and got into trouble with the law as a result. And he was facing deportation. And years ago, I represented Peter, and I won him relief under the Convention Against Torture from Sudan. The immigration judge found that he would be tortured in Sudan if he were sent there. And so then Peter got released from detention and went about his life. He has a U.S. citizen partner, 2 U.S. citizen children. But one day, about 15 months ago, he was taking out the trash at his house with his partner and his 2 kids. And ICE agents surrounded him and said, "Hey, we're sending you to South Sudan now." Now, Peter has never been to South Sudan. He wasn't born there. He's never stepped foot there. It only became a country in the last few years. And he also was terrified to return there. So ICE was prepared to send him to South Sudan without ever seeing a judge, without any process whatsoever to determine whether he would also be at risk of harm or torture there. Had a lawyer not gotten involved, that's exactly what would have happened. They would have put him on a plane to South Sudan without any kind of judicial process.
So they tried to take him to South Sudan um, after you already got him relief under the Convention Against Torture, correct?
That's right. So he had relief under the Convention Against Torture for about, let's see, almost a decade, 7 or 8 years. And then ICE decided they had enough of him and wanted to try to send him to a third country. Now, it just so happens that South Sudan is, this new country next door to Sudan. And in fact, we're seeing a lot of folks in similar situations to Peter who ICE is trying to send to South Sudan. But they really could have tried to send him anywhere. And without our intervention, they probably would have done so.
So can you tell us a bit more about this Convention Against Torture? I know that we've ratified it. It's taken a while to actually set up the apparatuses such that we can even comply with it whatsoever. What is this thing?
Yeah, totally. So CAT, or the Convention Against Torture, is this 35-year-old watershed international human rights treaty, was negotiated and ratified by the United States. It wasn't implemented until 1998. It wasn't self-executing, and so Congress had to pass the Foreign Affairs Reform and Restructuring Act, or FARA, to implement the CAT. For our purposes, the most relevant part of the CAT is Article 3.1, which reads, "No state party shall expel, return, or extradite a person to another state where there are substantial grounds for believing that he or she would be in danger of being subject to torture." Basically, what it comes down to is that because we're a signatory to this treaty, we don't remove non-citizens to places where it's more likely than not that they will be tortured. However, once CAT has been granted, the regulations do permit the government to remove a non-citizen to a third country. But they don't spell out any process for doing so. So although they allow that a non-citizen can be removed to a third country, they don't tell us how that should be done or what safeguards should be put in place, what process should be offered, nothing like that.
So essentially, ICE has this giant loophole by way of this regulation, allowing them to pick up people and to try to remove them extrajudicially with no guidance from anything else, no formalized processes or anything like that.
That's sure what it feels like. And I should note that, this is increasingly important in this particular political moment. And not just because under the current president, we see an uptick in the number of folks being detained and subject to deportation. In fact, we've been seeing that growth for years, including under the Obama administration. I think it's really important we talk about the fact that what's happening under Trump is not happening in a vacuum. It's the sort of inevitable trajectory that has been set out by previous presidents, by Clinton, by Obama. This detention and deportation machine was not built in a day or even 2 years. It's longstanding. But CAT is particularly important and indeed, I would say vital right now, because what we're seeing by this administration are unrelenting attacks on the asylum process. So asylum has gotten much more difficult to obtain, and asylum is a discretionary form of relief for people who are fleeing, in some cases, torture or persecution. And so if people are denied asylum as a matter of discretion or for any number of reasons, including recent case law from this attorney general, or because of the asylum ban or metering at the southern border, all these different sort of insidious attacks on the asylum process, if they can't get asylum, they're left ostensibly with relief under the Convention Against Torture. So now, if relief under the Convention Against Torture isn't as protective as we thought it was, we're talking about vulnerable people becoming even more vulnerable.
So CAT really is sort of a lifeline for those people who've been denied asylum then.
That's correct. It can be, especially because it's not discretionary in the way that asylum is. CAT is mandatory. If it's found that it's more likely than not that you'll be tortured in your home country, there is no discretion. A judge has to grant you relief under the Convention Against Torture.
So, how do we go about defining torture for purposes of CAT?
That's a great question. There's been some debate about what constitutes torture, but essentially, under CAT, torture is defined as an act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed, intimidating or coercing him, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or another person acting in an official capacity. So that's the formal definition, but ostensibly what it comes down to is it is some act by which severe pain or suffering is inflicted, usually by a government official or someone acting in an official capacity for a specific intent. So that's ostensibly what has to be shown. What it would look like, just to give you sort of more clarity on what it might look like in Peter's case, what we're arguing is that the government of South Sudan will detain him as soon as he arrives in South Sudan and will torture or kill him in their custody. In this case, because of his ethnicity, but it really could be for any reason or no reason at all.
So, the evidentiary burden that non-citizens need to show to claim CAT relief is, I mean, it shouldn't be that onerous, though, right? It's not like it's not like proof beyond a reasonable doubt. It's more likely than not. So, it seems like this should be something that's much more available to non-citizens and easier to get. And um, have there been any struggles with courts interpreting what torture means, such that it's limited this relief to people or anything like that?
That's a great question. It actually is pretty hard to get. So, in order to give you an example, to get asylum, you have to show a 1 in 10 chance, a 10% chance that you will be persecuted on account of one of 5 protected grounds. So, it's a really low hurdle to clear for a non-citizen. Of course, it's very hard for many other reasons. By comparison, CAT, as you mentioned, is more likely than not. So that's 50.1%, or different courts have interpreted it slightly differently. But it is often hard because it's often hard to show that, for example, what you're going to suffer constitutes torture, or that you're going to be, or that act is going to be committed by someone in government or someone acting in an official capacity. And usually, what it requires a respondent to do is to get country expert information. So maybe country reports that spell out what happens to people like this person when they're deported, or maybe they have to get an academic or a journalist or a politician or somebody to come testify about what happens for folks like this non-citizen. And all of that requires resources. So if you're unrepresented, if you don't have access to counsel, if you're detained in a remote detention center where you don't have use of a computer or the internet, it's nearly impossible to get access to all of the corroborating information you would need to make your case.
And it sounds pretty much near impossible then if you don't have resources, if you don't have connections to attorneys and the like. Um, so what kinds of relief are available to people under CAT? I think that there are 2, right?
That's right. There are 2. There's deferral under CAT and withholding of removal under CAT. So, ostensibly, you actually get ordered removed by the judge, and then your removal is either withheld or deferred. And without getting too much sort of in the weeds here, there are some differences in terms of who is eligible for each of those, but both of them are mandatory if the standard is met.
But then it sounds that once CAT is granted and that sort of relief has been granted, just to return to this removal to a third country, the government might have the chance to just take a non-citizen and take them to this third country, like you were talking about. You'll have to refresh my recollection under what provisions that's available, but essentially they're allowed to do this, remove someone to a third country, but then there are no other outlines of any procedures or protocols for actually doing that, correct?
That's correct. So under 8 CFR 208.16F, the regulations say that nothing in this section shall prevent the service from removing a non-citizen to a third country other than the country to which removal has been withheld or deferred. So the fact that this is possible is not in dispute. But the question is, what is the procedure or protocol for carrying out this option? And you can't, one sort of logistically, you can't raise a defense to third country removal at the time of your actual hearing because you don't even know what country ICE or DHS is seeking to remove you to until after you've been granted relief to your country of nationality or citizenship, and proceedings are closed, right? So if I tried to introduce, for example, if I had a client who was seeking CAT from, let's say, Ethiopia, and later on DHS tried to remove him to Kenya, I couldn't have raised any defenses to that at the hearing because I didn't know where the government was going to try to remove him at that time. And if I had tried to speculate, a judge surely would have said that that information was irrelevant and would not have admitted that information into evidence. So it puts non-citizens, even when they have lawyers, really in a bind because we're trying to speculate about what DHS may or may not do. And, we can't offer irrelevant and inadmissible evidence in a court proceeding. And so we're kind of stymied until after the proceeding is concluded. And then hopefully we somehow get word of what DHS is trying to do. But again, those are a lot of ifs in a system where people are not guaranteed a right to counsel.
I can't believe that this is so very speculative. I feel like in any other context, this would be very obviously a clear procedural due process violation. Not having notice, not being able to defend yourself against, what might be coming down the chute, and having to really guess as to what, DHS is going to do. I'm not exactly sure how people are supposed to handle that with so little guidance. And it seems that people have really been struggling trying to figure out, okay, what exactly can we do mounting defenses to this? How exactly can we combat this? From what I've been able to glean, doing my own research, it seems like there's even very little that's even been written about this third country deportation process. So it's exciting to see this paper really filling in that void and, approaching this problem.
Thank you.
Yeah.
Yeah, I should say, I think that's right. There really isn't very much written, if really anything written about this sort of third country deportation problem. Although, I should note that I am building on the work of other really phenomenal scholars that have looked at these sort of shadow deportations. So folks like Shobha Wadia and Mary Holper and Jill Family and others who have written Lindsay Harris and others who have written about expedited removal and sort of removal that happens in the shadows outside of a formal court process. I think what we're seeing is sort of this menu of options that's available, or this sort of increasing in number menu of options that's available to DHS when they want to do something outside the purview of a court or a judge. And, I think that's especially dangerous in this context when we're talking about people who, for whom English is not typically their first language. The immigration statute is hard enough to navigate when English is your first language. It's hard enough for skilled lawyers to navigate. We're asking people who have, been survivors of torture and trauma to navigate this really complicated system, usually on their own. And there isn't a lot written about it. Now, courts have opined a little on this. And when they weigh in, they almost uniformly say, DHS is kind of engaging in bad behavior. Now, the contexts are slightly different than Peter's story, but very similar. For example, in a Ninth Circuit case, DHS sort of last minute designated a new country of removal in the proceeding. And even that, the Ninth Circuit said was totally impermissible. This came up in a Seventh Circuit case as well, where the Seventh Circuit said this was a fundamental failure of due process. So to your point about this being an obvious due process violation, and in another case in the Seventh Circuit, the court again said the government was doing a sort of end run around the law, waiting to raise the prospect of third country removal until the non-citizen had no process by which to contest it. So we're seeing it percolate up to the circuit courts here and there. But I do think it's one of those things that is certainly happening a lot more than we know, just because of the nature of anything that happens in the shadows. We don't know about it because it's happening in the shadows.
Well, I'm glad to see at least that some of this is coming to light, along with the difficulty that respondents have because they have so little in the way of resources or kind of experience or sophistication in the system, or even knowing how to approach these problems. So there might be your paper really does outline though some at least some limited forms of recourse that some of these respondents might take. So could you maybe go over those for us and some of the difficulties even in using these?
Certainly. So, so if I first sketch out what I think are some existing remedies that respondents, that non-citizens might pursue. Again, a lot of these depend on having access to counsel, which I just have to keep sort of reiterating is not a given or a guarantee by any means. But at least hypothetically, some of the mechanisms available would be a motion to reopen or reconsider the case. A motion to reopen requires you to state new facts that'll be proven at a hearing and have it be supported by affidavits or other evidence. In the case of Peter, that's exactly what we did. We filed a motion to reopen. There are limits on motions to reopen. There are time and number limits on motions to reopen. And in fact, even though Peter had what I hope was competent legal counsel, our initial motion to reopen was denied, and we had to actually go up to the Board of Immigration Appeals. So, which required Peter to spend many months away from his family in detention while we litigated this. And we eventually did get the case reopened, but it took, tenacity on the part of his lawyers, but more importantly, patience on the part of Peter, who was, waiting in detention for a really long time, wondering whether this was going to work. The other thing that folks can do are habeas petitions to challenge the legality of deportation. Federal district courts have jurisdiction to hear habeas claims by non-citizens that are contesting the lawfulness of their detention. But again, we're talking about mostly pro se litigants. And it's also worth noting that in Peter's case, we have filed multiple habeas claims, and yet he remains detained. And I don't think that's due to our ineptitude. It's that the deck is really stacked against Peter in this regard. So these solutions have been, in some ways, both inadequate and ineffective for Peter.
And I know that looking at the paper, this is, a chunk of your paper describing what pro se respondents seeking relief really run into. And, it's a description of immigration law, but, we could certainly apply this, I think, to seeking habeas relief too. It is notoriously complex, like you say. You could describe it as labyrinthine, hyper-technical, and known to cause waste, delay, and confusion for the government and petitioners alike. So it's very troubling to me, and I'm sure a lot of listeners out there to hear how little guidance there is and how little help some of these respondents might have. What should we be doing differently in this country then, given, our being a party to CAT, our due process requirements in this country, sort of the, international law obligations that we've decided to take on in the past?
Yeah, thanks for that question. I think, as will come as no surprise, the article kind of concludes with basically saying that our domestic and international legal obligations require us to do more than we're doing as a party to CAT to ensure, that we're providing the procedural protections that non-citizens are required to have. And I also talk about some due process requirements and protections under the APA, the Administrative Procedures Act. In the end, what I really come down to is fairly simple and probably unsurprising on some level, which, and could really be woven into a Matthews analysis, but is really that we need notice to the respondent, which seems, pretty obvious, right? If the government is going to try to send you to a third country, you should be notified that that's going to happen. So adequate notice, that there should be burden shifting, that it should be not the burden of the respondent, but the burden of the government to show that that you'll be that you'll be safe there, and then finally. And finally, a full evidentiary hearing where the non-citizen can present her claim in front of an immigration judge and seek relief appropriate relief from that third country.
So, we've gotten to get to know Peter and his story a little bit, just through chatting with you. And those of you who, decide to read the paper, which everyone listening should, will learn a lot more about Peter. But could you maybe tell us more about him? Where is he at today? What's his life looking like?
Yeah, thanks for asking. And I wish I had better news about Peter. I can say that Peter unfortunately remains detained. It's been more than a year that he's been in detention away from his children. And he has, vowed to keep fighting his case. And we are still litigating his case in front of the immigration judge. So hoping for good news in the weeks to come, but that's where we're at right now.
Well, I really do hope that you guys hear some good news soon, not just for him, but for his partner and his, American citizen children as well.
Thank you. I couldn't agree more.
Great. Thank you so much for joining me and discussing this paper with me, everyone. You can go and find this very shortly through the Indiana Law Review. It will be forthcoming later this spring. Thank you so much.
Thank you so much for having me.
Came in on the red eye to Dallas Fort Worth, all the way from sunny Taipei. Skin the color of a walnut shell and a baseball cap, holding down her black hair. And she came here after midnight. The hot weather made her feel right at home. Come on in. We haven't slept for weeks, drink some of this. It'll put color in your cheeks. He drove in from Mexicali, no worse for wear, money to burn, time to kill, but 5 minutes looking in his eyes, and we all knew he was broken pretty bad. So we gave him what we had. We cleared a space for him to sleep in, and we let the silence, that's our trademark, make its presence felt. Come on in. We haven't slept for weeks, drink some of this. It'll put color in your cheeks. They came in by the dozens, walking or crawling. Some were bright-eyed, some were dead on their feet. And they came from Zimbabwe, or from Soviet Georgia, East St. Louis, or from Paris, or they lived across the street. But they came, and when they'd finally made it here, it was the least that we could do to make our welcome clear. Come on in. We haven't slept for weeks, drink some of this. This'll put color in